the flock camera situations. A lot of states are saying these flock cameras are dangerous. They're taking them down. They're not going to use them. There's bills going to be passed. And yet, for some reason, I don't see anyone talking about how straight up these mass collection tools are just straight up unconstitutional. I have looked this up, I don't know, a dozen times now, because every single time I look at it, I lose my mind. I don't understand how these things are in use. I've asked fucking AI, I've looked it up 10 different times. It is unconstitutional for the government to have access to mass collection tools. It is unconstitutional. It is against our Fourth Amendment rights. I asked Grok, I said, has the mass collection of U.S. citizens' data to be used by the government considered unconstitutional? He said, yes. In several key instances, mass or bulk collection of U.S. citizens' data by the government has been ruled illegal under statutes or likely or actually unconstitutional under the Fourth Amendment, which protects against unreasonable searches and seizures. Mass collection is considered a mass search. Actually, it's considered both mass search and seizure. Courts have not issued a single blanket ruling covering every form of government data collection. That's because of the Patriot Act. But specific programs and practices have faced successful challenges. Yeah, you'll win every single time. And so I've been completely surprised as to why nobody who's been wrongfully accused, or even why somebody who has been accused using these tools, hasn't managed to run it up the courts. NSA bulk telephone metadata collection post-Snowden. After Edward Snowden's 2013 revelations, the NSA's bulk collection of Americans' phone metadata, numbers dialed, call times, duration, etc., but not content under Section 215 of the Patriot Act, was heavily litigated. In ACLU versus Clapper, 2015, the U.S. Court of Appeals for the Second Circuit held that the program exceeded the statutory authority of Section 215. So what they're saying is, even though Section 215 of the Patriot Act, and let me see if I can just run it to it real quick, it says, expanded pen register trap and trace authority metadata collection. So we'll look into that a little more specifically when we get to the Patriot Act. But even this is saying that it went too far. It's a violation on a violation. It did not formally decide the constitutional question, but noted serious Fourth Amendment concerns about the staggering scale of collection of data on millions of Americans not suspected of wrongdoing. You'll win every single time. You'll win every single time. Our Bill of Rights are designed so well that they have to make up bullshit in order to go around them. A district court in Clayman versus Obama found the program likely unconstitutional. In 2020, the Ninth Circuit similarly concluded the collection violated FISA and that the government may have violated the Fourth Amendment. Yeah. Congress responded with the USA Freedom Act 2015, which ended the NSA's bulk collection of phone metadata under that authority. The government may still obtain targeted records with court approval using a specific selection term. Supreme Court precedent, Carpenter versus United States, 2018. The Supreme Court ruled 5-4 that the government's warrantless acquisition of historical cell site location information, this is the using tri-location, and they use your position in between 3 cell towers to determine where you are. Records showing a person's approximate location over time from cell towers constitutes a Fourth Amendment search. Individuals retain a reasonable expectation of privacy in the detailed chronicle of their movement, even though the data is held by third-party phone companies. So again, I can keep scrolling. There are more than 5 more cases here that pretty much all say the same thing. It's unconstitutional. You guys wouldn't believe how much rights you actually have. You wouldn't believe the shit you're technically allowed to say. You wouldn't believe the shit that they're doing that violates your rights. They're not supposed to be able to know exactly where you are at all times. That's not legal. It's not legal. It's not legal for them to access your bank records all the time. I remember when that got implemented. That's illegal. Sorry, if there was one thing I could change in our government, it would be to take away the Patriot Act. I assure you, all of the government surveillance, which, might still happen anyway, but really it would get scoured into the deepest, darkest corner in some tunnel, comes from the Patriot Act. Patriot Act is single-handedly the biggest violation of our rights. I don't know since what before, to be honest. No idea. Maybe since they started seizing Japanese people during World War II. Honestly. This narrowed the older third-party doctrine from cases like Smith v. Maryland for certain sensitive, comprehensive digital records. The ruling was narrow and left open some related issues: real-time tracking, short-term data, or national security context. Other relevant rulings and practices: geofence warrants. Requests for location data from all devices in a geographic area during a time period. Some courts, including the Fifth Circuit, have called them unconstitutional. Modern-day general warrants under the Fourth Amendment because they lack particularity and sweep up data on large numbers of non-suspects. Illegal. The Supreme Court has also addressed privacy interests in such location data. Section 702 of FISA. This allows warrantless surveillance of non-U.S. persons abroad with incidental collection of Americans' communications. Yeah, I was actually watching one of the hearings where they were talking about this, and I found it so interesting. So basically, if your number was in the phone or your contact information was in the phone of a foreign person outside the U.S., then you were fair game, no matter what. I thought it was crazy. They'll do anything to get around it. Courts have generally upheld the core program, but backdoor queries, searches of collected data for U.S. persons, identifiers without a warrant, have drawn strong criticism, some adverse rulings. A 2024-2025 district court decision found certain warrantless Section 702 queries violated the Fourth Amendment. DNA collection. Challenges have arisen over bulk or overbroad DNA collection by agencies such as DHS and CBP, including of U.S. citizens, with arguments that it violates the Fourth Amendment when it exceeds statutory limits or lacks sufficient safeguards. So, for an example of this, I don't know if this is taking place. This is just like theoretical. It probably is, but again, theoretically. Was it 23andMe, I think? Ancestry.com, whatever. Those companies that you can get your DNA tested for your fucking ethnicities and shit. It's possible that the governments could buy access to that DNA and store it in a local database. That's actually what they do for a lot of mass collection of data here in the US. They just buy it. A lot of it from the CIA. Oh, so the CIA does a lot of the buying. Sorry. Some judges have blocked or criticized large-scale databases combining citizens' personal data as violating privacy statutes or constitutional principles. Yeah, Palantir. Palantir will soon have access, if it doesn't already, to a lot of your medical records. They signed a contract with the government to help store and process all of that. They say that it's more just creating the database itself and handing it over, but, I mean, come the fuck on. When have they not put a backdoor? When? Key limitations and nuances. Not all government data collection is unconstitutional. Targeted collection with warrants, right. So, the way it's supposed to be done is a warrant is signed, and then they're allowed to search and seize. That being said, there's also this kind of newer system where a judge will just sign anything. A mass collection in an auto pen-like fashion. Targeted collection with warrants, collection under properly authorized foreign intelligence authorities with minimized procedures, or data that falls outside a reasonable expectation of privacy can be lawful. Many challenges fail on standing grounds. Plaintiffs must show concrete injury or because of the third party doctrine, state secrets privilege, or national security difference. The Supreme Court has not issued a comprehensive ruling declaring all mass bulk collection of citizens' data unconstitutional. Outcomes depend on the type of data. Interesting. Metadata, location history, DNA. The method, the scale, the legal authority claimed, and whether a warrant or equivalent process was used. Congress and agency have reformed some practices after court losses or public scrutiny, ending bulk phone metadata under Section 215. Okay, so at least one little section of the Patriot Act has been ended. Jeez, 25 years later. In short, courts have repeatedly treated certain forms of mass collection of U.S. persons' data as unlawful or unconstitutional, especially when it is warrantless, overbroad, and captures sensitive information about people not individually suspected of crimes. Ongoing debates continue around commercial data purchases. That's what I was talking about earlier, where obviously your data is for sale, the government can buy it. Section 702 queries location tracking and large databases. So, all right.